Okay, Mr. Monk.
Good morning. My name is Brandon Monk. I'm here for the plaintiffs. I'm here with Mr. Larry Watts, who is the attorney that sponsored me into admission at the Fifth Circuit, so I'm honored to have him at the table with me. This is an honor to be before you and before you with this argument. The way I want to start out in talking about this case is talking about the fraud component. I think there are two components that we really need to analyze. We've got the fraud component, and we've got the specific jurisdiction component as to Gilda Franco. I'm happy to address other issues, but that's where I plan to spend most of my time. On the fraud component of the case, this is a case where there was admitted intentional fabrications of documents. That came through the form of this memo from Counsel. Although the memo was vague, it doesn't make a complete mea culpa in terms of what the fabrications were. There's at least in this case an admission that there were fabricated documents. So with the fraud analysis, we start with that. We start with the fabricated emails, but we also have internal communications where Silver Fern is internally hiding the ball from Wright Price Chemical and the Daughtry family about whether they would be leaving the market. And they specifically say in an email that's attached to the complaint that they were not going to tell RPC that they were leaving the market. And then finally, the document that we look at for the fraud claim is the Counsel memo itself. Because it is an ongoing fraud, not a complete answer as to what happened, we've had to continue to spend resources to try to find out the nature of the fabrications, and even today we don't know the nature of all the fabricated documents that were directed to us. So on the fraud claim, it's important to know Silver Fern was our sole supplier of this substance 1,4-butanediol during all the relevant times of the prosecution. There's some question in this case as to whether these documents made it to us in a form that we could rely on them, and I think that's the big issue. Yeah. In terms of that reliance component of this, there are cases that we can point to, and I'll point to a few. Ernst & Young, I think, is one that we cite to in our brief, but there's also the Summit case and the Sandwich Chef case, which I could further supplement to the court if necessary. But those cases deal with the aspect of reliance and the potential that could come through some third-party communications.
Right, but a false statement to an accountant, there's a reasonable expectation it's going to go on. Here, right, Ms. Franco was communicating directly to the prosecutors for whatever reason to help prosecute your clients or to avoid culpability. But where was there any expectation that whatever misstatement she made would be then relied on you?
I think the fact that it was going to go to the government, that was known by Gilda Franco
right.
and by Silver Fern. And eventually, the process is that those documents will make it in the criminal discovery to us. And I think everybody had an expectation, and that's exactly how we received those fabricated emails, was through the criminal discovery in that case.
Okay, so you're relying on Rule 16, obligatory discovery. These SDSs, the safety sheets, had to be disclosed in the criminal prosecution to you. And that's your reliance? That's the government's complying with its discovery obligations, right?
It is the government's complying with the discovery obligation, but I think what we're seeing is that Gilda Franco and Silver Fern knew about that dynamic and knew that those documents would make it to us and that they'd be used against us in this situation. And as a result of that, that reliance component is satisfied.
Well, the government relied on them clearly. And although it's not, I've read there have been multiple appeals from the criminal side.
Right.
And I've read motion to withdraw, motion for new trial. None of that seems to have been infected by the safety data sheets. Correct me if I'm wrong. Because the guilty plea, he said, I illicitly distributed these date rape drugs.
The real nature of the guilty plea is with respect to this particular authorized user component, and the exact language that my client used when he talked about maybe what he did wrong at the guilty plea was that he did not get this in user form, and that's really where that standard came from in the criminal case.
But once you plead guilty, you're not entitled to even Brady anymore, right? The discovery process is over. So if he says under oath, I'm guilty, well, why would there be any expectation of any document ending up in the defendant's hands?
I think there's an he did get those documents before.
He did get them, fact.
Before he pled guilty.
And is there anything we can look to the record to say those documents were crucial to the decision to plead guilty?
The key document there is the Carr-Tuttle memo, because that memo is issued in December of 21, right close to the guilty plea.
Right. But I have even more. I'm just testing you, so this doesn't display my view. The Carr memo, that's done by a law firm. How was that? I guess two questions about that. How was that ever? It was for Silverthorne. There was no expectation that's going to go anywhere, I don't think, but disagree if you say so. And then secondarily, that memo, what's the falsity in it? I can understand Ms. Franco's falsities.
So it was actually my client that had found out about the fabrications
Right.
and covered those, right?
Once the discovery came, I assume.
Right. So when he raises that issue and he brings it to the government and say, we've got fabricated documents.
Right.
Well, at that point, there's an attempt to try to explain that. The memo comes from the paralegal Carr-Tuttle, but it's really issued with the intention to explain to us.
Right, but the government doesn't tell Carr-Tuttle to go look in. That's Silverthorne saying we need to figure out what's going on, or that's unclear in the record.
Well, the government does tell them, go explain this.
Tells Silverthorne. They seek outside counsel.
Correct.
Outside counsel generates the memo interviewing.
Correct.
Maybe help me, what's the clearest false statement in that memo, whether or not it was relied on by your client?
The clearest false statement is that, they omit the nature of the full fabrication. They do not tell us.
It's a falsity through omission.
Correct. And they also, in that, they fuddle with the timeline. They say that it's not clear, and Gilda doesn't know whether she did this in 2017 or 2021, and then they use a vague reference point, which is Friedman, this lawyer's involvement in the case, as the way to try to stake out the timeline. So they're hiding the ball in terms of the timeline of when these fabrications were made as well through that memo.
And law firm's hiding the ball.
On behalf of Silver Fern.
On behalf of Silverthorne, then to be communicated to the government, then you think the Carr memo was disclosed, and don't we have to trace all the way back and ask, was the law firm trying to get you to rely on a false statement that they...
I think the question is whether Silver Fern and Gilda Franco were, because they were using this law firm as their agents in this situation.
Okay.
So, the paralegal, issues the memo where she claims to have been at the meeting, tries to provide detail about the nature of this, but it's not enough. But we do have that looming over us at the time of the guilty plea. And in fact, we're concerned that there are more fabricated documents in the case, that we have not had that explained to us, but that the government's apparently thinking about accepting this explanation from Silver Fern and Gilda Franco about how those fabricated documents came into the case. So that is absolutely critical to our decision to plead guilty. But I think the court could look at that in another way. The court could look at it
When you filed your motion to withdraw, you knew about some of this uncertainty?
We did.
But it was not a basis for the motion to withdraw?
It was part of the motion to withdraw the guilty plea.
That's been affirmed on appeal.
It has been. There's a pending 2255, which I think is really the biggest aspect for relief
That's what I thought.
in this case. And so we've discovered information that really, truly, GHB was only emergency scheduled. And so there's a challenge to the underlying conviction as a result of that 2255 as well. That's proceeding. But this concept that Silver Fern had an effect on the criminal prosecution also comes from the testimony of Agent Salome in the case. He specifically says that there was nothing that had the force and effect of law that would make the sale of 1,4-butadiene illegal. And he goes on to say that the only way that they could establish the criminal nature of my client's conduct would be to establish some kind of voluntary standard that they were complying with. And that's what these documents are about. These documents are about trying to fill the void. We also have a failure to warn claim here. We think that is a duty that's relevant to maybe the fraud by nondisclosure.
Just so I understand the basics, Ms. Franco didn't claim she sent the safety sheets, but she didn't.
Do
I have that upside down?
She did not send them to my client as part of the original email.
Your client's the distributor. So how would that have any relevance to whether or not illegal distribution occurred?
It would have provided him information. In particular, there is some language in there about GHB.
Oh, he would have read it and then known?
He could have.
Didn't know. Okay.
Correct. He had no knowledge whatsoever. And this knowledge that's needed in this area is pretty unique because it's an analog.
I'm just testing you. Maybe it's the habeas. I won't go any further. But if he had no knowledge, why did he plead guilty?
He was worried that they were going to continue to go forward with these fabrications at the trial of the case. And the memo it looked like maybe going to be accepted as an explanation by the government, and it was not true. And he knew that it was not true, but he was concerned that he wouldn't be able to beat that fraud at the trial, given his counsel at the time, which was also ineffective.
Before you get to the products liability claim, do you have an opinion on minimum contacts for Ms. Franco?
I do. I think they're satisfied through, specifically, you get a long way in this area through the intentional tort. I'm not saying that you get all the way there, but you get a long way in this area there. But then further, she knew that this customer was an Eastern District of Texas customer. Some of the emails that were fabricated, if you look at the expert report attached to the complaint from Psyopsis, not only did she fabricate to us, she also fabricated to an IDC warehouse in Pasadena, Texas. And so there were multiple.
Not just the subpoena compliance, it's the whole blast of emails, even the original ones that were incomplete. All those show contacts that she would then expect to be hailed into Texas court.
That's exactly right. That's exactly right.
Her client, I'm sure that you'll hear counsel get up, from the briefs, they'll get up and say, well, there's case law that suggests complying with a subpoena alone isn't a sufficient contact. What's your thought to that?
Exactly, and that's not what she did. She did way beyond that. I think when you comply with a subpoena, you're not necessarily required to fabricate documents. That's a deliberate, intentional act. When the subpoena came through, she had a fork in the road. She could have chosen at that point to go to RPC and say, well, we made a mistake. We did not provide this information to you. We're going to provide it to you now, and we're going to go forward that way.
I mean, the district court's dismissal, did it just rely on non-jurisdiction, or did it go on to say, in the alternative, we dismiss as to her on the merits?
I think it was a dismissal on the merits as a result of this fraud component as well, because I think the court saw that the same way.
I see. Thank you.
Yes, thank you. So yes, in terms of the specific jurisdiction argument, just carrying that forward a little bit more, you have the intentional tort, you've got the Weir Alaska case that deals with that, and then you've got the Lewis versus Fresney case, which deals with that as well. Talks about the fact that there could very well be a limited contact. In fact, I think there's a case, McGee, that talks about a one instance of an intentional tort could establish specific jurisdiction. And in this case, we do have much more than that. So I think that...
The hardest case for you, I think, is Claro versus Mason. Do you remember that?
I do remember that case.
What's your thought about that?
Let me look at my notes here.
Southern District of Texas.
Thank you. Yes, it's
back to this notion that if people respond to government subpoenas, it's involuntary.
Right. So, yeah, I mean, this is more than a subpoena response, and it continued on through the memo. I think the fact that they issued the memo trying to explain the subpoena response shows the court that it is much more than just a simple process issue here.
Okay, thanks.
On the constructive fraud claim and the fraud by non-disclosure claims, just to address those briefly, there is the ability for the court to consider that the duty would have arose as a result that they should have warned. There's in the case law mentioned that there could be special relationships, or could be some aspect of the course of dealings that could establish that duty to warn, and both for the constructive fraud claim and for the fraud by non-disclosure claim, we think that's important for the court to weigh.
Duty to warn that they're going to stop distributing to other chemical suppliers?
Really, in terms of the warnings, I would think that if Silver Fern's going to represent to the government that there's going to be a need to supply an SDS with every order, that there's going to be a need to have an end user form, and those representations are made, well, they have to have some basis to think that that was their legal duty to need to go fabricate documents to satisfy that burden. And I think that's what we have here as their recognition, at least, that there was a duty that would apply to those other contexts of fraud here. In addition, in terms of the fraud by non-disclosure claim, to the extent that these were documents that were omitted and that they recognized that they should have provided those, then there was an obligation at that point to go forward and make that submission complete. If there was a material aspect that needed to be corrected, then it should have been corrected. And so there's additional fraud in the sense that once there's a recognition that these SDSs and documents are not going to Right Price Chemical, that they should do something to get out of that circumstance, and it should be honesty as opposed to fabrications at that stage. At this point, unless there are other questions.
You're not going to press much on the product liability claim.
Well, the product,
Non-consumer that didn't cause physical harm? There's not really much Texas law that would suggest liability here, or you want to preserve that on the briefs?
I think we want to preserve that on the briefs, but I think importantly, it establishes the duty that Silver Fern had with respect to these other fraud claims, and I think that's the last point I'd like to make with that.
All right, thank you, Mr.
Thank you.
Monk. You've saved time for rebuttal. Mr. Hutton.
Good morning, and may it please the court. My name is Andrew Hutton. I'm here today on behalf of appellee Gilda Franco. To briefly answer Judge Higginson's question, there were two grounds that the district court decided that the dismissal was appropriate as to
You're
Ms.
defending
Franco.
on both?
Pardon me?
You're defending on both?
Yes, Your Honor. The first being the personal jurisdiction issue, the 12b2 issue. The second being the 12b6 issue, and whether there's valid fraud claims pled against Ms. Franco. I'd like to start, if it's okay, with the personal jurisdiction issue, since that was the first issue that was addressed by the district court. I'd submit that what is missing from Mr. Monk's presentation on specific jurisdiction, but is unquestionably critical under both this court's and the Supreme Court's jurisprudence, is some kind of non-conclusory allegation that Ms. Franco herself created a connection with the state of Texas, the forum state here. It's not enough that appellants live in Texas. It's not enough that they allegedly suffered their harm in Texas. It's not even enough that it was foreseeable to Ms. Franco that they might suffer harm in Texas. The facts of this case, I think, are colorful. In fact, they may even be sui generis in the annals of the Federal Reporter. But in many ways, they rhyme very closely with the Supreme Court's decision in Walden versus Fiore. To refresh the court's recollection on that, that was a case where a police officer that was working in the Atlanta airport stopped the plaintiffs in that case and seized almost $100,000 as part of a civil forfeiture. He was aware that those plaintiffs were from Nevada. They were getting on an airplane to Nevada. He nevertheless held the cash and declined to return it to them. Once they left, he allegedly filled out an affidavit that the plaintiffs alleged was false and misleading, and submitted that to prosecutors as part of the civil forfeiture. The Supreme Court made very clear in that case, actually the Ninth Circuit decided that false affidavit issue, which very closely aligns with the allegations of falsity regarding the emails in this case and the creation of those emails. The Ninth Circuit decided that knowledge that the plaintiffs in that case would be harmed in Nevada, foreseeably harmed, based on the fact that this affidavit would be used against them in a civil forfeiture or used against the funds, was enough to generate personal jurisdiction. And the Supreme Court specifically rejected that notion, said that the foreseeable consequences of that intentional tort were not enough to generate personal jurisdiction. Instead, the police officer had to themselves generate some kind of connection with the forum state himself.
But here it's prosecutors in Texas that subpoena her for records that the allegation is she doctors.
Correct, Your Honor.
Sends it right back there. And the thought is due process would be offended if she thought she might be held accountable for false statements? No, you couldn't have jurisdiction over for perjury?
I'm not sure that, well, first to start with, as far as the government's action, it's important to recognize that's a third party. We're not talking about the plaintiffs
But we are asking whether the court in Texas had jurisdiction over her.
Correct, Your Honor.
Okay. And my point is, she gets a subpoena, she sends back false incriminating documents, no way to hold her accountable?
What the jurisprudence says is that she has to create her own contacts. She has to be I think the language of the court is reaching in.
That's when I look at these cases like Claro and others. Those are just pure responses. Those aren't intentional torts, the malfeasance of sending in something that's going to be an obstruction of justice not only on the court, but arguably cause a defendant to plead guilty and go to jail. Still, through all of that intentional tort, there's no jurisdiction in Texas to hold her accountable? That shocks.
That's our position.
That is your position. What's your best case?
The best case is, well, I would start with the Walden case.
Yeah.
Judge Higginson, your opinion in the Danziger case.
You didn't cite Danziger, did you, in your brief?
Pardon me?
Did you cite Danziger in the brief?
I'm not sure that we did, Your Honor. I can't recall.
I think you can all check. I don't think anyone did. That was a single response to an email.
Correct, Your Honor.
Seems pretty different than many, many emails. I mean, documents arguably doctored, sent for the purposes of prosecution. Considerably more substantial contact with Texas.
But the connection with Texas is not created by her voluntarily or
So
intentionally.
is the key the voluntariness? You can lie as much as you want, but as long as you're in Arizona, no one's going to hold you accountable?
Well, from her perspective, the contact with Texas is fortuitous. It had the creation, the issues that connected it to Texas were
I'm
appellate.
just testing this, so don't think I have an opinion. I'm just, at the same time, these doctored items correspond to the actual mailings that she voluntarily sent on behalf of Silverthorne to the supplier client. Correct? She's sending the BDO, and they lack these safety data sheets. So it's part and parcel of the whole thing.
It requires those original emails
Yeah.
that were sent to Texas.
Yeah.
That she sent to Texas. These claims don't arise out of those, and clearly in specific jurisdiction cases.
But they're inextricably tied, because they get those. Their theory is they think they're innocent. They're not warned this stuff's going to cause date rape stuff. And instead, then all of a sudden the government gets it, and whoa, they were told it did, so we're going to go after them. Isn't that the theory? It's the mismatch.
I'm not sure it is, Your Honor. My understanding of their theory, and certainly.
Yeah. No, that's all right. Don't go into that. Keep going with your argument.
Okay. The reality is here that Ms. Franco did not generate herself any specific connection to Texas. She allegedly altered these emails, presumably at her home state in Arizona or at the California workplace of Silver Fern. The only connection to Texas is generated by this fortuitous contact, which could have arisen anywhere from her perspective, between the criminal prosecution and the third party being the federal prosecutors reaching out into her home state of Arizona or into the state of California to obtain those. And it's our point that those contacts were generated strictly by a third party or by the plaintiffs. And under the court's analysis in Walden or in Danziger or in the Singha case, those connections are insufficient to create personal jurisdiction under these circumstances.
Danziger.
It makes no difference if she responded truthfully or falsely. There's still no jurisdiction.
But that would go to the merits, I think, Your Honor, but I don't think it goes to the jurisdiction issue. Because that has to be a connection that she generates herself, and she just didn't. There was no specific reaching out by her into Texas that created conduct that gives rise to the claims here. That's our position. I'd also like to...
Subpoenas expect truthful documents that, according to them, would not incriminate. So it was through her falsity that suddenly the defendants, the Daughtries who were being prosecuted by the government, end up getting prosecuted. That's their theory.
I think that's their theory, Your Honor. I think there's problems with that.
Yeah.
Certainly, but first of all, they recognized the falsity immediately, apparently. That's the allegation here.
I guess my point is I see Walden and Danziger as very different. Those are civil cases, sort of the question Judge Douglas was asking. If you affirmatively decide to send more than what the subpoena requests, and it is incriminating, and it is falsely incriminating, it sounds to me like that respondent to the subpoena is availing herself of the Texas court and there would be no offense to due process if she was then held accountable.
Our argument would be the contrary.
Yeah, okay, good.
You're saying Walden gives the same response.
It does, Your Honor. That's our position, is that Walden, which also involved an allegedly false affidavit in that case, that would have involved a consequence in Nevada based on the civil forfeiture issues. counsels and controls this case, that that is insufficient to establish personal jurisdiction. I see I'm almost out of time, but I did just want to raise one issue, which is the 12b6 issue, which it seems that Mr. Monk's entire analysis is focusing on the Carl Tuttle memorandum rather than these emails. It would be our contention that the reliance on the emails, which is what the district court addressed in its opinion, that element is missing here, and therefore...
Even more so as to the memo.
Absolutely, absolutely. Thank you very much, Your Honor.
Thank you, Mr. Hutton. Mr. Sherry?
Good morning, Your Honors. Jim Sherry for Silver Fern Chemical Supply Company. I think Judge Higginson is the only one who's mentioned one of the most salient facts in this case, which is that 2 of the plaintiffs in this civil case pled guilty to the federal trafficking offenses in the analog drug BDO. That was Jack Daughtry and Joseph Daughtry. They did so in January of 2022. That was after their own retained expert had analyzed both versions of these emails and identified this discrepancy between the emails, okay? It's also apparently after they had received the law firm paralegal memorandum about the interview with Ms. Franco, where she apparently admitted at some point doctoring some version of the email to attach the SDS form and add a sentence to it. So I think what the district court really found as to each of the fraud theories pled is that there's some breakdown in the necessary connections between fraudulent statement communicated to plaintiff, in this case, justifiable reliance thereon. And as I was listening to Mr. Monk, I heard 3 identified acts of fraud. One being the fabrication of the email itself, right? This is a, I believe, June 2017 email. It is, I submit, unclear from the record when the fake or doctored version of the email was produced to the government. I think there are points in the record, including in the complaint that was the subject of the order of dismissal, where the plaintiff claims that act of alteration occurred in like March of 2021. I want to make one point about the guilty pleas. The guilty pleas were to knowingly distributing this date rape drug for a period of time from 2011 through July of 2020, with acts beginning as early as 2016 of reducing the size of the bottles that the BDO is being sold in. So rather than being sold in big industrial size tanks for legitimate applications, it's being sold in little 100 milliliter bottles. Both of the Daughtry's, Jake and Joseph, pled guilty to knowing that customers were buying the BDO for personal consumption. Okay, so it was not merely a technical not getting the authorized user agreement. In every case, their guilty pleas include a plea of knowing that that was the use that was being made by at least some customers for that period of time. So the fabricated emails, the district court correctly recognized that the breakdown in the chain there is no communication to and therefore no possible reliance by the Daughtry's or any of the plaintiff group in this case. The theory on the doctored emails is that at some point they got to the government and at some point may have informed the government's investigation. They couldn't possibly have started it, right? We received a subpoena, a grand jury subpoena from the government was already investigating the Daughtry's and Right Price Chemicals. It was some point after the receipt of that grand jury document subpoena that the version, the doctored version of that email was produced in some form. Although I submit the record is not clear exactly about how it came to the government's possession. There was apparently an affidavit in the criminal cases that it was found at the Daughtry's office in a drawer.
The gravity of the underlying criminal offense pled to, you're right, isn't really before us. Am I right that the legal issue before us is, and this is me restating your position, just tell me if I'm wrong, that even if a person makes a false statement to another one, knowing that that will harm them, i.e. criminal prosecution, it's not actionable unless the third party, the defendant in the criminal case, himself relies on the false statement? Is that?
I think the elements of a common law fraud claim under Texas law always require communication somehow. It can be via a chain.
And you heard what they said, is they know the government has to turn over its exhibits.
Yes.
So they would have known you would get it, and then, I'm not you, sorry. They would get it. No, okay, I'm mixing things up. Yeah, they'd get your false statement, and they might do just what they did, which is plead guilty.
So I think Your Honor is putting your finger on something, which is what supposed false statement induced who to do what?
Yeah.
Are we talking about at each of these times, right? There
Yeah.
may be a theory that the government's investigation was induced or influenced in some way by the production of a false version of this email. Is that the harm that's being complained of? I would say the guilty pleas are relevant there because they shut that off. I mean, how is that an injury when at the end of the day, many months after they're aware of the discrepancy between the emails, they choose, with advice of counsel, to plead guilty to the offense, including a fact.
That wasn't exactly how the district court ruled. It didn't say, stay in front of the microphone, sorry. It didn't say, oh, well, they relied, but we've got an intervening plead guilty, and therefore they've discounted their own reliance. I guess I'm asking you for the abstract. Maybe it's the Ernst & Young case they cited, which is person lies. They know that lie is going to end up on a third party and cause them harm. Still not actionable unless there's some reliance by the third party?
So this is what I think is not explained. I don't think it's explained how the plaintiffs did anything in reliance either on the production of that email or their receipt of the email in the criminal discovery.
I agree it's a little unclear, but aren't they implying this is what they pled guilty?
No.
Maybe not.
It can't be because they knew it before they pled guilty.
Okay.
Their experts
I see that
providing a
point.
report in March of 2021 that is laying out the difference between the version that was provided by Silver Fern to the government, right, and the version that they got via a subpoena directly to Silver Fern, right? So they were comparing the
Was it
criminal
necessary for
discovery
us to
version.
affirm to say that they would have been convicted with or without these SDS forms? Is that necessary for us to say? And we know that because they already saw the discrepancy before they pled, so therefore, or is that not necessary?
I certainly don't think you need to get there, Your Honor, again, because they were pleased.
It's their blue.
I think, though, your question is getting to a theory of reliance, which would be our failure to attach the SDS form to that email in 2017 induced them to sell, right? And here I think a fact that the district court pointed to, which is super important, is that is in December of 2019, there is an email from Silver Fern to the Daughtry's and to Right Price Chemical informing them, hey, warning, it's an analog to a date rape drug. It can have illicit purposes. You need to get the authorized user agreements. So from December of 2019, and their confessions, pled to offenses continue through July of 2020, they are on notice that they need to get authorized user agreements and that it can have this illicit use, right? So there's always, like I said, a breakdown between what is the fraudulent disclosure or non-disclosure, what is the person that it's communicated to, because it's inextricably linked with reliance, right? If it doesn't hit their ears, they don't rely on it. So that element of the claim fails as well. And this, just to make the point finally, Your Honor, that's in the record at 503, ROA 503, that's the first amended petition in the case, is an email from December 4th, 2019, where Silver Fern is advising Right Price Chemical about the potential for illicit use of BDO and the necessity of getting an authorized use agreement. So the guilty pleas, again, this is the relevance of the guilty pleas, is that there's a period of time of admitted, knowing sale to individuals who are using it for consumption after they have been put on notice of that. I just want to make one point. I think the district court's analysis of the grounds for dismissal of each of these counts is pretty clear and straightforward and grounded in good law. There was one point made in the briefing that I do think is worth emphasizing again based on the guilty pleas with respect to Mr. Daughtry, Jake Daughtry and Joseph Daughtry specifically. There are other plaintiffs, of course, but which is judicial estoppel, right? I mean, they, maybe Mrs. Daughtry does not or the companies do not, but they have allocutions and guilty pleas in these cases where they admit, to the elements of the offenses, which are knowing distribution of these chemicals to people who are using it for personal consumption. Thank you, Your Honors.
All right, thank you, Mr. Sherry. Mr. Monk for a rebuttal.
Thank you, Your Honor. I want to begin by addressing the Walden case because I think it's important to remember.
You don't know Danziger, or you don't?
Apologize. I wish I did, Judge, but no. On the Walden case, I think it's extremely important to remember that those seizures occurred in Georgia, and that was a big part of that decision, was that there was activity in Georgia and not necessarily in Nevada with relation to the seizures themselves. That makes it very different than this case, and I think it sounds like to me more like Danziger. The fabricated emails were a choice. I think that was an intentional act. They did not have to do that. That was something Gilda Franco intentionally did. That is purposeful availment under the case law to intentionally send fabrications. There was mention about 2011 to 2020. Clearly the time frame of the prosecution was 2015 to 2020. I just wanted to correct that. I think that the court is looking at some things in relation to the guilty plea. And I just want to point out, obviously there is that consideration. That's not the basis of the trial court's ruling.
It didn't rule on estoppel. Is the
Correct.
factual basis even in this record?
I don't think that it is, Judge. I don't. Actually, I take that back. It was referenced by Silver Fern and some of their documents through judicial notice, at least in a footnote, I think. But to the extent that we're talking about reliance and we're weighing that in terms of whether or not it would have been justified to rely on these communications, I think that's a fact issue, and that's really not something that the court weighed in on. The existence of reliance, I think, was what the court focused on. But I hear the Silver Fern arguments leaning more towards, should we have relied on these things? Was it justifiable? And I think that's beyond where we are.
Just clear, as a basic theory of your case, the reliance was the guilty plea or the reliance was to keep selling?
Well, the reliance was that Silver Fern is not telling us anything that we need to be concerned about related to this substance.
So you kept selling.
So
it's not so much that by virtue of relying on what was omitted, you pled guilty.
Well, we kept selling. That's part of it. But then the other part of it is once we get into the criminal case, we received a certain set of emails. And then the government starts to make contact with Silver Fern. And in December of 2019, when they're talking about that end user form, that's motivated by whatever government contacts they've had at that point. None of that's revealed to us. There's nothing from Silver Fern that comes to us and says, well, we've got a sudden change of the standard of care that we need to try to acknowledge here.
But you don't dispute chronologically. You got the discovery before you pled. You looked at it. You saw the discontinuity. So going into that guilty plea, your clients knew about this discrepancy.
We did not have all the metadata. We did not get all the metadata from the emails. We had to ask for that one at a time, and then that came to us from Silver Fern. As we asked...
there'd be a floodgates problem, arguably, because this is a sort of creative case. Every time a defendant pleads guilty, they turn around and sue the accusing witness saying, well, what you said was incorrect. I'm not sure fraud claims that are just bilateral exist maybe as much as defamation. That's just my instinct, but it's complex. But I thought the real argument you were making was you relied on the omitted SDSs in selling and continued to selling.
That's part of it.
Part of it, okay.
I understand your friend on the other side to say that there was a notice of potential illicit use through Record Doc 503 in December of 2019?
So that document is the one that is the very first time we ever get any kind of an end-user form claim out of Silver Fern. And the prosecution, the raid occurs on July 15th of 2020. The indictment's June 3rd of 2020. And we had been selling and dealing with Silver Fern from 15 until 20. So December of 19 is the first time that we ever get any kind of a document like that. And it's limited. It is not a document that tells us we have an obligation to somehow get an end user form. It's not an SDS. It does not mention anything about GHB or an analog path, which was the language that was in the SDS in particular. So there's some information that comes to us at that time, but we're under investigation already by that point. We should have been told about that in the years prior. And in fact, when they go back and they alter the email from 2017, that really shows the court the effect of this. They were able to time travel to 2017 to make it look like historically they had given this information, and they actually had not given us this information historically. So there was a problem in 17, 15, 16 that they were trying to solve. That was what the fraud was about. That's what motivated for Silver Fern and Gilda Franco.
All right, thank you, Mr. Monk. Your case is under submission, and the court will take a brief recess.